Mr. Arnold.
Thank you, my lords. Just before the short adjournment, I said I was going to go into the treatment of the evidence below and the question of the appearance trap. And in answer to my Lord Justice Nugee's request, we have copies of the affidavits en route. I think they're still being printed. But I've asked that they be brought to the board. It's only a small bundle, I think, totaling something like 50 pages. I might put that another way and say it's 50 pages of engagement with the case, but in terms of case management, it's not a major point. I'm hoping they'll arrive before I need them, but I can keep going without reference to the affidavits themselves for the next little while. They're not the first reference I need to take the court to. It was said yesterday, and it's said in the company's skeleton argument, and indeed in the skeleton argument in 868, that there was an assumption, what I've referred to as the appearance trap, an assumption begging the question that because Miss Khan was there and participating, she was fit to participate, whether you call that fit to plead or having capacity under the Act. And a point that was repeatedly made yesterday is that the fact of giving instructions doesn't matter. It's the quality of the instructions and their cogency, by which I don't mean whether they're right, but whether they are pertinent and directed to the issues in the case, that matters. And in my submission, it's simply wrong to say that the learned judge made any assumption that because Miss Khan was participating and giving instructions, she was able to do so. There was no such assumption, and the judgment is very clear that that error was not made. Rather, at 22 to 23 of the confidential schedule, and again at 24 and 25 to 6, the judge carefully considered the evidence of other engagement in the proceedings and in these proceedings and in other proceedings, and was right to say that they showed that she, in fact, was able to understand the issues in the case and met all the other requirements for having capacity. I took the court before lunch to the criticism made of Dr. Gupta that he hadn't dealt with Khan 1 to 4, and the specific finding he made in the liability judgment that Khan 1 to 4, as he put it, betrayed a thorough understanding of the terms of Mr. Justice Miles's order. The other points, just to deal with them before we turn to the affidavits, are in 24, 25 and 26 of the confidential schedule. So just to find the reference, we are in Core Bundle, tab 11, page 128 to 129. There is a witness statement after Dr. Gupta had carried out his assessment, which was made in support of an application for an extension of time. And as the judge said, it's clear from that she had read the liability judgment and also understood the order which was made on the 2nd of March. It's clear that to make that statement, she had spoken to her solicitors and made the statement in reliance upon information provided by them. And she says she was working on an affidavit in which she proposed to give evidence to show she had purged her contempt. And the learned judge said, I find it impossible to see how Ms. Khan could have made this witness statement if she did not understand what was required to do to purge her contempt and could not instruct her solicitors. Then at 25 through to 26, so one might say in broad summary, 22 to 23 is Khan's 1 to 4, her substantive engagement with the allegations. 24, Khan witness statement 1, shows her procedural engagement with the proceedings almost at exactly the same time as Dr. Gupta was making his assessment. And then 25 and 26 deal with other litigation. which went to the question of whether her disability left her unable to understand proceedings. And it discusses, among other things, cost of proceedings between the firm and the SRA following the intervention, in which she had made a without prejudice offer and served the points of dispute and supplemental points of dispute on 27th of February 2023, 2 days after her meeting with Dr. Gupta. And again, there was the metadata before the court showing that she had amended or modified both documents. And then there is the reference to other litigation for over a number of years when Ms. Khan had been involved with the SRA, and she had often represented herself. And he concluded her conduct at both hearings, as evidenced by the transcripts. So, my lord, it's not merely that she was there and heard what she said. Do not suggest she had any difficulty understanding the proceedings or defending herself. And also with impeccable timing, the affidavits have arrived. If I might hand these up. I've prepared one for my learned friend in case
Very kind.
it's helpful to have the same copies. I say I've prepared. My instructing solicitors have paginated this and put it together neatly, and my clerks have printed it, so the credit is all elsewhere. Thank you. There are 3 points in the liability judgment which I propose to address to show that the judge was right to make the finding that her engagement with the proceedings betrayed a thorough understanding of the terms of her order, of Mr. Justice Miles's order and her obligations under that order. The first, these are dealt with just to give the references now. I'll turn to them again in turn. 3 specific matters on which allegations were made in the contempt proceedings. Firstly, the use of what was called the Soophia Khan email address. Given that we're live streamed, I'm not going to read out the actual email address, but it was referred to as the Soophia Khan address. Secondly, on proceedings in which JFP were acting and Soophia Khan and Kara had previously been acting in a matter known as the Banon file, which was an inquest, or 2 inquests to be scrupulously correct, and then also on the Coulthard file. And these are all each dealt with in turn in the liability judgment, and they each illustrate in my submission why the judge was plainly right, and in any event plainly entitled to make the finding of fact that Ms. Khan fully understood what she was required to do under the order, and fully understood the criticisms that were being made of her in the application.
Yeah, well, you've got the 4th affidavit, which I see runs to 112 paragraphs and includes a detailed account of Ms. Khan's case in relation to the Banon file, the Compston file, the Blackwell file, the Forcer file, the Mahoney file, the Baxter file, the Shilliter file, the Coulthard file, with Martin file, Corbridge and Naylor file, other clients, and she goes through and discusses them all in great detail and with great lucidity, whether it's cogent or otherwise.
My lord, yes, and I am going to say it is cogent. The learned judge was satisfied on many of these cases, including
I mean cogent in terms of proving her case.
Well, I was going to say cogent as to her case. On some of these points, the learned judge was satisfied to the criminal standard that it was fundamentally dishonest evidence. But it was cogent. And the first example of that, not actually one that my lord just mentioned, I was going to take the Sophie K email address. And actually, the place to start with this, to follow the judge's reasoning, is, I think, the actual injunction itself, which we have in the what's called the single bundle for the appellant's applications. I think this, in fact, has nothing to do with any of the appellant's applications, but was a document that has ended up in here because it was impossible to agree a single supplemental bundle. But the order of Mr Justice Miles is paragraph, it's tab 21.
This is his second order. He made an order at the outset.
In fact, it's his, yes, my lord, it is his second. It is the third in total. Just to briefly orientate ourselves with the chronology. Following the intervention into Miss Khan's practice and that of her firm, an injunction was obtained against Miss Khan and Sophie Khan and Co. And that was made by Mr Justice Adam Johnson on the 7th of September 2023. So, i.e. in these proceedings, D2 and D1. In fact, that was technically made in a different set of proceedings, because Ms. Khan then said, well, actually, a lot of the files are now in the hands of Just for Public Limited, and therefore exercising powers in respect of documents in the hands of third parties that are provided for in the Solicitors Act. This is all set out in the judgments made by Mr Justice Leech. New proceedings were brought against all three of the defendants, so catching Just for Public under the injunction as well. So that was the Adam Johnson order first, and then Mr Justice Miles' order was that second set of proceedings covering all three. And the first committal proceedings were in respect of breaches of both of those two orders. And then, in line with some of the guidance in the case law, following Ms. Khan's committal to prison for contempt of court on the breach of those two orders, a fresh injunction was obtained to secure compliance with the original obligations. That is, there's guidance from the Court of Appeal in other cases, which we don't have, it's no longer an issue, that is the correct procedure. And so that is what we have in Mr Justice Miles' order of the 27th of April 2022. And it's paragraph 1 that I particularly want to start with for the Sophie K email address. And paragraph 1 specifies the obligation to deliver up to the agent, that's the SRA's intervention agent, all listed items in their possession or control. I'll turn to listed items in a moment. It says, including, for the avoidance of doubt, any emails which are listed items that are held by the account for the following email addresses. And then one sees a couple of email addresses, of which what I call the Sophie K email address is the first. And then there are provisions for how they should be delivered. There's also a very important provision which the learned judge placed great emphasis on in paragraph 5, requiring a witness statement setting out what steps have been taken to comply with the order, and where listed documents haven't been provided, why, and when they will be provided. Much as one would see, and Mr Justice Leech made this analogy, in a standard freezing order, to allow the operation of the injunction to be policed, effectively, to allow compliance to be policed. And Mr Justice Leech made much of the fact that although on some cases he couldn't find, to the criminal standard, that listed items had been withheld, as in that they were still on the 27th of April in Miss Khan's possession or control, where he could not find that, that was because she was also in contempt of the injunction in paragraph 5, which he regarded as at least as serious, in that it had deprived the court of the opportunity to monitor its compliance with the order. But sticking with the email address, as the definition of listed items is found in clause 20, paragraph 22.7 of the order, page 135, which simply cross-refers to Schedule A. And then Schedule A starts at the very foot of 136. All documents and property, including without limitation, 1, any files and the contents thereof relating to present or former clients of the practices. And 7 is also any computer, hard disk or server used in connection with the practices. So to put the point like this, if it were right that an email address had never been used for client matters, and although held on a business server was therefore in fact contained purely personal emails, then there is a good argument that it falls outside the scope of the order. Entirely incontrovertible, because it actually says in Schedule A all documents and property, and therefore there was some debate about this. But there is a cogent case that if it were only ever used for client matters, isn't it never used for client matters and only ever for personal emails, then it falls outside the scope of the order. And having looked at that, my lords, can we turn then to the liability judgment, which is tab 10, paragraph 42, which is on page 62. And Mr Justice Leech referred to Schedule A in paragraphs 5 to 7 as including individual emails sent to or from or copied to Ms Khan or the firm or JFB in connection with their practices. And then the point is recorded that actually there was some debate about whether the mailbox itself was a listed item, even if it didn't contain any practice documents. And Mr Justice Leech accepted my learned friend's submission that that wasn't the correct analysis, and the mailbox was only included if it contained something which was in itself a listed item. 45 is important. Ms Khan did not disclose any emails from the Sophie K email address at all. In Khan 1, she gave evidence that she had not had access to the mailbox since May 2022. She was silent about emails sent or received before that date. If I can pause there, my lords, since we have it now, and given that the court's expressed an interest in seeing it, and ask the courts to turn to Khan 1, paragraph 39, which is on page, it's been very helpfully paginated, page 10 of the bundle as a whole, page 9 of, if you're looking in the centre of the page. Paragraph 39. And that's the evidence that Mr Justice Leech was referring to. Now, the Sophie K email address, the answer that's given in Khan 1 isn't a complete answer to the allegation of contempt, because she says she hadn't had access to it since the end of May 2022. And of course, the order requiring her to deliver up those documents was made in April 2022. And therefore, in my skeleton argument from December 2022, I made that point. Oh, sorry, no, the skeleton argument dated January 2023. There were a number of supplemental skeletons. I made that point. This is recorded in paragraph 45 of the judgment, that this didn't actually answer the allegation of contempt because on the evidence she had access to the mailbox at the time the order was made. And so, as Mr Justice Leech records, in Khan 4, served, in fact, just slightly after I had started opening the case on behalf of the SRA. We were told about it at about 10:27. It was served shortly after that, while I was on my feet. Paragraph 109 makes the case that there are no practice emails sent to or from that address, thereby setting up, if I can put it like that, my learned friend's submission that means it's not a listed item. And that is, I'm slightly slow on some of the pagination of this new bundle. That's page 52, paragraph 109 of Khan 4. And actually, if we look at that, you can see that what was being done in a lot of this document, particularly in 108 and 109, it's very clear, was a direct response to the SRA's skeleton argument. 109 starts, as to paragraph 53.2 of C skeleton 2, the email address, Sophia K, was a personal email address and its mailbox only contained emails personal to me. Accordingly, there were no listed items in that mailbox. And in any case, after the mild stay order, I searched it just to be sure. Now, the arrangement that was made to deal with the fact that Khan 4 was served only as the hearing was starting was that I would open the case on the evidence as it stood in Khans 1 to 3. And then, irrespective of whether Ms. Khan chose to give evidence or not, if she chose to deploy Khan 4, I would close, taking into account that evidence. In other words, that I would continue with the openings as they had been planned before Khan 1 arrived, and then deal with Khan 4 as any other evidence which arrives during the hearing would be dealt with. And everyone was happy with that. So that's why it says in closing submissions in paragraph 46 of the liability judgment, the learned judge records that we had already in the bundle identified 12 emails and an attendance note which Ms. Khan had either sent from or received at the Sophia K email address between the 8th of April 21 and the 22nd of April 2021. All relating to what is called the Blackwell file. Both emails to a new client, to his client's new solicitor, and emails to the client herself. And at 47, there's a reference to 3 further emails from another firm relating to a long-running dispute in the Corbridge and Naylor cases, and an email dated 29th of January 2018, this is halfway through 47, which appears to have attached a letter on the letterhead and signed by Ms. Khan herself in relation to a Mr. Hussein's case. And then the conclusion at 48, I reject Ms. Khan's evidence that she did not use the Sophia K email address for work purposes. It is self-evident that the emails to which Mr. Alquist took me were not personal emails but listed items. The subject matter of each one was business of the firm, and Ms. Khan used a signature, Sophia Khan, Solicitor Director, Higher Court Advocate, Sophia Khan and co-solicitors and Higher Court Advocates. And office addresses of the firm and so on were also included in the signature. At 49, he makes the point that Ms. Khan didn't produce any of these emails herself, but actually that the SRA's evidence had happened to exhibit all of them to support the case that we were running, that Ms. Khan had refused to deliver up the files of former clients when asked to do so by those clients. So as it happened, there was already evidence before the court in the affidavits and their exhibits showing that the case in Khan 4 was wrong. It also showed that it must be deliberately false, because Ms. Khan said that, or purported to say that she had searched it just to be sure that there was nothing there. That's the last sentence of 109 of Khan 4. And then at 50, the learned judge accepted my submission that Ms Khan had effectively here been giving the deliberate impression that the only files she kept were hard copy files, and made a series of findings about the use of electronic documents. And at 51, he drew the inference that the mailbox for that email address contained hundreds, if not thousands, of emails relating to the practice of the firm. Now, when I was looking at 52, I'm just going to correct something I said which was probably not quite very well expressed. I don't think you can say from 49, as I just did, that the existence of the evidence shows that the search was false, that the evidence on the search having taken place was false. That, the basis of the finding of it being deliberately dishonest is 50. Because His Lordship declined to draw the inference that they still existed on the mailbox as at the 27th of April. It was possible, effectively, he says in 50, that Ms Khan had deleted all of the emails and electronic files before the Miles order of the 27th of April was made. Now, that might be a breach of the earlier Miles order or of the Adam Johnson order, but those were not contempts that were before the court on this application, if that was the case. And so that's the finding he made at 52. So what one sees from that is two things. Firstly, that there was a series, effectively, of exchanges. Ms Khan put forward, or we put forward criticisms, Ms Khan put forward an explanation. We scrutinised that application, found it wanting, made the point, and new evidence, a piece of evidence came in, engaging with our skeleton argument. It too was demonstrably false. It also shows not only that she is engaging in the cut and thrust, if I can call it that, of the adversarial debate, but that she is doing so and demonstrating, as His Lordship puts it, a clear understanding of the terms of the order. Because to say there are no listed items there requires you to understand the caveat by reason of the structure of paragraph 1 and the definitions in Schedule A to the order that a person, if it was used purely for personal email addresses, personal emails, it wouldn't be something that the SRA needed to see. So her evidence not only shows that she understands our criticisms, understands the case and the case we're running in the skeleton, but also that she understands the order. You see exactly the same, my lords, on the Banon file, which is dealt with in the liability judgment at 53 onwards. My Lord Justice Arnold and Lord Justice Nugee may have faint recollections of some of the points that were made on the previous appeal about clients wanting their files to remain with Just for Public, and this is an example of one of those cases. It's not that point I really need to deal with today, but the question of whether on the 27th of April, Ms Khan or Soophia Khan and Co. or JFP had the file in their possession or control. And leaving aside what was said, for now, leaving aside what's said in 53 to 55 about the evidence given before the Miles order, starting with the Miles order in the chronology at 56. The point is made that following the Miles order, Ms Khan did not deliver up the Banon file. She gave evidence in Khan 1 that at the end of January 2022, she had hand-delivered the case files to Mrs Banon. And I don't have all of these references immediately to hand, but this one is straightforward. This is paragraph 38 of Khan 1 on page 10 of the bundle, 9 of Khan 1 itself. She said case files had previously, last sentence of 38, case files had previously been hand-delivered to Mrs Banon at the end of January 2022. Now, we made the point in our skeleton argument after that, and this is quoted in full by Mr Justice Leech at paragraph 56, essentially that there was evidence that JFP had continued to represent the Banon family at the inquest in question after January 2022. And so there's a reference at 4.1, the subparagraphs have been merged together, but at 4.1 there's a reference to a pre-inquest hearing on the 1st of June 2022, same coroner giving a ruling about following submissions by JFP through Mr Khan in this case on the 31st of October 2022, and there are various points on both JFP and Ms Khan's personal Twitter account, posting tweets in November 2022 about the outcome of the inquest and describing Ms Khan as the Banon family's lawyer. Now, there was some debate below about whether that description was a description given by the media or something that was thereby adopted by JFP, but the point is that JFP was still representing the Banon family at the inquest in question all the way through 2022, and how, we said to the learned judge, does that reconcile with Ms Khan's evidence in Khan 1 that she'd given the file back in January 2022? She can't possibly have gone to the inquest with no papers. That point was then answered, as Mr Justice Leech put it in paragraph 57 in Khan 2. And we have actually the whole of the relevant evidence there, quoted in the judgment, but the reference, it is paragraph 6 of Khan 2, which we can find on page 16 of the bundle. And the court will note that in deference to making some point about the clients and their confidentiality of their legal advice, the first names have been redacted from His Lordship's quotation, which they weren't in the affidavit, obviously, but I will follow Mr Justice Leech's guidance there. And essentially the case that one sees coming out of Khan 2 is that E. Banon had been the client for an inquest up to October 2021, and then that inquest ended with the jury being discharged, and then there was a fresh inquest in 2022, but by that time it was a new client from the Banon family, B. Banon, who was instructing JFP. And she says at the end of A, which again you'll see is a direct reference to paragraph 4.1 of our supplemental skeleton argument, she says, since the client was a new client, it has no relevance to the subject matter of this contempt hearing and of the delivery up or non-delivery of the documents required by the Miles J. order. The point there being that if it was a new client that had come direct to JFP and handed the papers direct to JFP, it's not part of the practices of Soophia Khan or Soophia Khan and Co., not therefore a listed item and not therefore recoverable under the delivery up injunction, even in the hands of JFP, because it hasn't come from one of the practices in which the SRA intervened. A very precise knowledge of the points and the respective roles of JFP and the basis on which JFP was a party. That point does not work unless you understand the fact that if it's a new client who's come direct to JFP, it's outside the scope of the powers of the SRA to seize documents in the hands of a third party. And it's outside the scope, as you would expect, of the injunction that Mr Justice Miles made accordingly. It's then said in paragraph 58 of the liability judgment that Ms Khan added details to her account in Khan 3 and Khan 4, and so we have evidence in Khan 3 that they are estranged. That was paragraph 6. It's actually worth turning that up. Paragraph 6 of Khan 3, page 23 of the bundle. And here she's effectively arguing the point very clearly. There were two different clients, one of whom, E. Banon, was a former client of mine or SK & Co. E. Banon told me, and I verily believe her, that she was estranged from the remainder of her family. Mrs. V. Banon, this paragraph 7, was never a client of mine or SK & Co. She was a client of JFP only. That's the point I was summarising, squarely and explicitly put by Ms. Khan in her evidence. The problem with it, as is recorded in the judgment, is that the pre-inquest review, see this in paragraph 58, the coroner had addressed his remarks directly to Mrs. E. Banon. And there was evidence of the trial, we don't have it today, but there was evidence in the transcript before the learned judge of those remarks being addressed to E. Banon. So why, one asks the question, if V and E are estranged and V is no longer the client, why is the judge, and V is now the client, but E is no longer the client, why is the judge addressing his remarks about who is giving the representation and the role the role JFP is taking to E. Banon if she is no longer the client? That was the point made in Miss Crawford's evidence in reply. And so we then have evidence in Khan 4, which Mr Justice Leech referred to as parrying the point from Miss Crawford, which is, I think, a good illustration of how clearly he saw this as part of the back and forth of argument. That V. Banon had stepped out because she had to go into the waiting room taking a call from her son's school at the time that ruling was made. That's page 36, Khan 4, paragraph 15. He also records, in fairness, and this shows the thoroughness with which he recorded and dealt with the evidence, that Ms. Khan had also said that the coroner's agenda for the hearing noted that Mr. Banon's daughter, that would be V. Banon, was taking the lead in the current phase. So there was some evidence that V. Banon had become more prominent, but no evidence, as we submitted and the judge accepted, of the papers being handed back, a change in who the client was, and a whole new set of papers from VB being used for the subsequent inquest. And the learned judge sets out in considerable detail in paragraphs 59, 1 through to 8, which runs all the way through to page 69 of the liability judgment, the reasons why he found that case to be incredible. They include numerous points, but for example, there was no evidence of the end of the retainer with EB or the new retainer from VB. He had seen many examples of standard form engagement letters, for example on the Humston file, and there was no evidence of any such change. It's also slightly bizarre to think that one might, even if they are estranged, that you would hand back a set of files to one member of the family and then ask for a completely new set of files from another member of the family on the same matter, okay, a different inquest, but the same underlying matter, and no one to think that this was odd or unusual or to need explanation. There'd be no trace of any of it. No receipts or confirmations or covering letters from the documents being handed back or received. All of these points are explored in 1 through to 8. And Mr. Justice Leech was satisfied to the criminal standard that it was untrue. Again, Reynolds, it is a relevant point that only works if you understand the order and if you can engage with the evidence that the SRA was adducing and seek to rebut it. And Mr. Justice Leech went further than that and recorded in 9, this subparagraph is worth focusing on, that he had accepted our submission that this was an example, reading now from 9, of Ms Khan deliberately seeking to exploit ambiguities in some of the documents, and in particular in the coroner's rulings, to come up with a new explanation for her failure to hand over the Banon file. And at the end of the paragraph, in my judgment, Ms Khan's evidence was no more than an ingenious attempt to exploit this ambiguity to avoid the conclusion that she had misled the court. And my lords, again, I say that is right, but plainly it is evidence that the conclusion the judge was entitled to reach on the evidence before him. The final point, my lords, is Coulthard, which I said I would go to, and that starts at 77. Paragraph 77, which is also conveniently page 77 of the bundle. And to set this one in context, my lords, it's helpful to start, although Coulthard is first dealt with in Khan 2, it's helpful to start with Khan 1. And that says that contained a number of visions following paragraph 36 onwards. In fact, we've looked at two of these already. 36 on page 9 through to 39, dealing with what happened with the listed items. 36 says, by the end of April 2022, JFP was no longer acting for any client or former client of SK in Co. And then at 37, there is a list of clients, inquest cases and other matters, where it said, well, they'd either found alternative representation or their matters had concluded. And the point we made, and then 38 and 39, she explains how papers were handed back and so on, and how the SK and Co email address wasn't relevant. The point we then made in the skeleton argument is that because of the documents we did have from the intervention, and in particular, either matters arising from earlier investigations into misconduct or documents arising, client names coming to our attention because their current solicitors had written to us saying, please can we have our client's documents, where we knew there were other clients who are not referred to in 36 or 37 and for whom there was therefore no explanation in Ms Khan's affidavit as to what had happened to the documents. And so Ms Khan then addressed that submission, continuing the back and forth in Khan 2, as this is quoted in paragraph 77, but is paragraph 9 of Khan 2, page 18. And we had named a list of clients who we were aware of who hadn't been mentioned in the skeleton argument. Arising out of the intervention decision that we had. It said, well, they all long predate the Miles J. order. The cases of Corbett and Naylor concluded in 2015. The cases of both Mr. Martin and Mr. and Mrs. Coulthard concluded in 2017, and the papers were retained by the clients and not the defendants. It's that line in relation to Mr. and Mrs. Coulthard that I want to focus on. I could go through numerous examples, but I'll just pick this one as the last of the three. Ms. Crawford's reply evidence, which is recorded in paragraph 78 of the judgment, drew attention to a previous witness statement given by Ms. Khan in proceedings against the SRA, by which she had said she delivered the original Coulthard and Martin files by hand to the SRA on the 21st of May 2019. But it was also said in another witness statement in September 2021 that she could provide copies to the SRA and offer to make arrangements to do so. So we submitted that the evidence that papers were retained by the clients at the conclusion of the cases in 2017, which is the impression that paragraph 9 seeks to give, appeared to be wrong because it was inconsistent with what Ms. Khan had said in a witness statement previously. And then one goes through further. There's reference to the production notice proceedings in front of Master Clerk at 79, in which a witness statement was made offering to produce evidence that copies of both files were in her possession at the time. And then at 80, emails or text messages from both clients and their solicitors from January 2023, which state emphatically, in the case of Mrs. Coulthard, that Ms. Khan had not delivered the original file, and that she had never received her files back from Ms. Khan. That's similar evidence from Mr. Martin's present solicitors. And then that criticism having been made in the reply Crawford evidence, there was then another attempt to deal with it in Khan 4. It's recorded in 81. The reference for that is 52. Khan 4, 52, page 43. She said, when I stated papers retained by the clients and long before the Miles order, I was referring to the non-retention of the papers and not referring back to the year 2017, which was merely the year in which the case is concluded. However, I accept that the last two sentences of paragraph 9 may appear somewhat ambiguous, and I apologise for any confusion caused thereby. And then there was also another point raised for the first time in Khan 4 in answer to the point we had made about her offer to produce a copy, whereby she said, I was finding the reference, this is paragraph 59 onwards, said paragraph 59, page 45. I did, however, retain a copy of the Coulthard files for use in the intervention, which started in August 2011, 2021, so would explain the comment in September 2021 that she could provide a copy. But they went missing, together with many of my intervention files, whilst I was in prison, as I discovered when I returned home. And she refers to the intervention challenge, which took place, and indeed the appeal against sentence, while she was in prison. And she had to prepare while in prison. And therefore, she said, paragraph 61, whilst in prison, I only had access to the telephone, and that on a limited basis, and due to COVID, no personal visits were allowed. I was therefore obliged to telephone and ask my brother Yusuf to send me the key intervention documents together with the other files, including the whole copy of the Coulthard files. And then it said that her brother had sent them, but they were never received. They either went missing or were retained somewhere in the prison system and not relayed. And the learned judge accepted our submission that this was a convenient excuse which she advanced when her previous inconsistent statements were exposed by the SRA's evidence. That's paragraph 83. And it's worth, as a final point, my lords, explaining, or making clear one final thought on the overall findings here, which is paragraph 100 of the liability judgment, page 85. These are the conclusions, and particularly two. Mr. Alquist submitted that Ms. Khan had made just too many incorrect or inconsistent statements supported by documentary evidence, that they cannot be mistaken, and that the court can be satisfied that Ms. Khan has made a sustained and deliberate attempt to mislead the court. I accept that submission. I'm satisfied beyond a reasonable doubt that Ms. Khan has deliberately attempted to mislead the court. One of the points here that is relevant, of course, is the way in which circumstantial evidence is treated. And the learned judge had quoted paragraph 29, that's page 55 of the liability judgment, the famous summary of the position by Lord Justice Ricks in the JSC BTA Bank and Abley as of number 8 case about the way in which circumstantial evidence works.
Sorry, that was where?
So the reference is page 55, paragraph 29. At the start of the paragraph, and then the quotation is over on page 30.
Yep.
And this was cited, of course, by my Lord Justice Nugee in Hussein. This is frequently cited in contempt proceedings, and the judge noted, as I pointed out, that my Lord Justice Arnold had expressed some criticisms of the phrase geometrical progression. But the point is, I think, indeed it was said by the learned judge and said by Lord Justice Nugee and the whole of the court in Hussein, is that the principle is that circumstantial evidence can have the sum being greater than the total of the circumstantial evidence is greater than the sum of its parts.
The famous analogy and better one is strands in a rope.
Well,
No individual strand bears the weight, but the rope as a whole does.
Yes, well, exactly. I had wondered whether to offer the possibility of a chain, which is proverbially only as strong as its weakest link, as against a rope or a web. But I think that's exactly the same point.
I'm not sure. I think my lord's point might be more apt.
It might be.
In the sense that if you have your chain and it's only as strong as the weakest link, that suggests that a mass of circumstantial evidence won't prove anything because there's some bit of it that isn't very strong.
Well, that's the point. It's not that.
Oh, I see.
It's not the chain.
I see.
Where you could knock out one piece of
That
evidence and
you
therefore
my
destroy
lord
the structure.
Agreed.
I think they're basically
Yes.
different metaphors for the same function.
Yes.
But the point I need to make, as interesting as that debate is that His Lordship had well in mind 29 and 30. And the point is, really, that there was just one too many convenient excuse, one too many document getting lost in the post. When you look at the totality of the evidence, all of the documents which were said to have got lost or gone missing, it just was not credible.
All right, but what's this got to do with capacity?
Well, what it shows, that point, my lord, is just to show you the reasoning behind 102, which was the conclusion that Khan 2 and 3 and 1 running back show a deliberate and sustained attempt to mislead the court. And the point then comes back to cogency. The points I've gone through on the liability judgment, they are relevant. If the coulter filed had been lost on the way to prison, it would be a reason why it was no longer in her possession by the 27th of April 2022, even though in September 2021 she said she could provide a copy of it. It got lost in the meantime. And there were too many examples of that for the judge to be so that the judge was satisfied, the criminal standard, that what we had here was a deliberate attempt to mislead the court. And it is a deliberate attempt to mislead the court which is directly and cogently related to the allegations and the criticisms of Khan 1, which are then answered in 2, criticisms of 2, which are then answered in 3. She was fully engaged in the proceedings. That's the point, my lords. And so this is why I spent so long on it, this is not an appearance trap case. It's not that at all. There was clear and compelling evidence, what the learned judge referred to as overwhelming evidence in the confidential schedule, that Ms. Khan fully understood what was going on and engaged in them fully. And that's the points that I really needed to take from the confidential schedule and the underlying evidence. And that's why he said, I just mentioned overwhelming evidence, the reference there is 30 sub 2 of the confidential schedule. That's where turning up is. It just brings me to an end of my submissions on this point. So we're back in tab 11,
Sorry to interrupt, I don't know if I wonder if my client might have another short break.
For what purpose on this occasion?
But again, reasonable accommodation for her condition.
I think
Well, I've got about 2 minutes more on ground one.
I think, Mr. Baker, we will take a break in a moment, but let's find a convenient point. So Mr. Alquist, you've got a couple of minutes more on ground one. How much more will you have to say on the main appeal after that?
Little, subject to your lordship's questions. I think probably only 15 minutes on adverse inferences.
Mr. Bogle, I think what I have in mind is that we should have a short break after Mr. Alquist has completed his submissions on the main appeal, and that may be convenient because then you'll know the totality of what he has said.
Bring them along.
So I wanted to round this point off with coming back to paragraph 30 of the confidential schedule. And these are effectively the judge's conclusions on the question of whether an adjournment should be made, it should be granted. And he says in paragraph 30, page 130 of the bundle, the real issue for me to decide is whether I attribute sufficient weight to those views, as being the views in Gupta 2, to direct further evidence or cross-examination on the question of whether Ms. Khan lacks mental capacity. I have reached the conclusion that the evidence which Dr. Gupta has given in Gupta 2 does not bear sufficient weight to take that course for the following reasons. So, well, that's the point I was making earlier, that this was fundamentally a case where he accepted that it would be suitable to adjourn if the evidence had sufficient weight. As he had said in the open judgment, this is the detail of it in the confidential schedule. He then sets out in subparagraph 1 that he has to assume Ms. Khan has capacity unless Ms. Khan or those appearing on her behalf persuade me otherwise. He referred to that by reference, as he should have done, and is correct to do, by section 1.2 of the 2005 Act. But as my Lord Justice Nugee pointed out at the end of yesterday afternoon, actually you'd be in the same position under the Pritchard test, because the defence raises the question for the defence to prove to the balance of probabilities. So, and then 2, he says capacity must be decided on the balance of probabilities, and that he is not satisfied that it is more probable than not that Ms. Khan is either unfit to plead or lacks capacity. That's a finding on the evidence as it is, and he says far from it the overwhelming evidence before the court, some of which I've just tried to take the court through, is that Ms. Khan has capacity to conduct legal proceedings on her own account or to instruct solicitors and counsel to do so. And then 3 is only a sort of further point, but in my submission it is essentially fatal in one of the appeal. I am not satisfied that Mr. Bagel has any real prospect of persuading me to accept the conclusions in Gupta 2, 101 to 106, even after further expert evidence and cross-examination, and in particular to revise the conclusion I reached in the liability judgment at 119, which was the point about her having a thorough understanding of the orders. The history of the committal application and the associated proceedings and Ms. Khan's personal participation in them throughout satisfies me that I should attribute very little weight to those conclusions. Referring back to the law where I started, my lords, GMC and Hyatt, Levy and Ellis Carr in particular, says a judge is bound to decide this for himself or herself, including, on all the evidence, including their own, the evidence of the proceedings as they've transpired before the court. And then there's a further example of that in 4. I take into account her conduct at the committal application. He gives the one example about the fact that after I'd opened the application, Mr. Bogle took 20 minutes to take instructions on whether Ms. Khan would be to give evidence, submit to cross-examination. He says, I have no doubt that she had capacity.
Can I just ask a question about that, since you've directed our attention to that paragraph? Because this relates not to ground 1, but to ground 4, which I know you're coming to. But I have to say, I find that deeply odd, because my understanding of procedure on contempt applications, which may be faulty, is you can't do what Ms. Khan was allowed to do. Now, this is not a point against you. On the contrary, it's a point that the judge if the judge erred, he erred too far in her favour. But what he allowed her to do was to rely upon her affidavit evidence without submitting to cross-examination on it. And my understanding is that's absolutely wrong.
Well, but
But it's an error in her favour.
The short answer, my lord, to your lordship's point is that is not a point we've taken in the respondent's notice. And it wasn't a point, to be fair, that we pushed before the learned judge. There was quite a lot of debate on the 6th of December about whether, and may need to come to this in a little more detail if the supplemental skeleton application is persisted in, about the difference between being directed to serve affidavits that you intend to rely on and being required to serve evidence. And there's authority, and in fact Ms Khan mentioned this, as we overheard to Mr Bogle yesterday, when the court was asking about it, the case of Deutsche Bank and Sebastian Holdings. And there's also another decision of Lord Justice Coulson, the name of which I could find in the transcript, saying, well, actually, to direct someone to serve an affidavit and then say, well, you've given evidence, so you have to cross-examine on it, would be to infringe the rights.
That's at a prior stage.
It is, my lord. So we had considerable debate on that, and then where that ended up was that Ms Khan put in her affidavits, relied on them, and then chose not to give oral evidence.
I can quite understand the proposition, which may contradict what I was putting to Mr Bogle yesterday, that the mere fact that you've served an affidavit doesn't subject you to cross-examination because you can subsequently choose not to rely upon that affidavit.
And there's clear Court of Appeal authority on that, my lord.
Fine. But that's a separate point. The point is, can you simultaneously rely upon the affidavit but say you won't be cross-examined on it? And that's what I'm jibbing at. But as I say, if I'm right in jibbing at that, and the judge was in error, he was in error in Miss Khan's favour.
He was, my lord, if he was in error. And as I say, having not taken that point below, I don't feel I can really take it now because it may have changed the course of the trial.
No, I'm not suggesting you should take the point now.
But
the point is that if I'm right about what I'm suggesting, it cuts the ground completely under from ground 4.
Well, it does, my lord, and actually that I was just about to say, I think in some ways the answer to this is that we put a similar point somewhat differently, which was by reference to the Hussain decision and my Lord Justice Nugee's point about adverse inferences.
Yeah, well, there's other reasons for dealing with ground 4, but I appreciate that.
But I mean, I think, well, we'll see this when I come to it, I think, now, unless there are any other questions on ground 1.
I had one question, which was you told us yesterday that the appearance trap finds a reference in one of the authorities, and I can't remember. I don't think you showed it to us. I can't remember what way.
I believe it's Solanki, my lord, but let me try and find that using the benefits in electronic bundle. My lord, it may be that I have taken that phrase from a decision of Mrs Justice Carr in the Divisional Court in Maitland Hudson, which we don't have in the authorities bundle, which applies Solanki, but it may be that that's actually then with Mrs Justice Carr's phrase. Would it assist the court if I brought a copy of that tomorrow? Wouldn't need to make any further submissions on it.
I suspect it's probably not necessary for my part.
I will leave it there, and if I can find a reference in the authorities bundle, I will mention it at the start of the day tomorrow. Thank you, Lord. Yes, so turning to ground 4 then, which I've said I can and will deal with now quite shortly. There are, in my submission, 3 points that need to be made here, in light of both the points that are made in the main appeal skeleton in 868 in the company's skeleton and in my learned friend's submissions yesterday. And I say the company's skeleton as well, because that was the first place where we saw in writing the suggestion that although Mr Justice Leech said he wasn't drawing inferences, it's hard to credit that, and he probably was. Taking these points in turn, 32 of the liability judgment deals with Hussein and the entitlement to draw adverse inferences. And it's readily recognised by Mr Justice Leech in his judgment that he was initially reluctant to accept my submission that an adverse inference could be drawn because of the classical position that an inference of guilt cannot be drawn from a decision to exercise the right to silence. But then, looking at Hussein and hearing our submissions on that, he accepted that in appropriate circumstances you could draw an inference if a sufficiently compelling case is set out that the choice not to give evidence suggests that there is no evidence to give, if a sufficiently compelling case is set out. So you're not drawing an inference from the silence.
This is not a case of a party being deprived of their right to silence. This is a case of a party who was allowed to have her cake and eat it. She was allowed simultaneously to put affidavit evidence before the court and yet not be cross-examined on it.
Well, the reason I say I think our answer to this below was Hussein is to say, well, actually, that's where you draw the adverse inference. If you've put in Khan 1, 2, 3, and 4, and actually I hadn't dealt with submissions on 4 at the time the election was made, so let's focus on 1, 2, and 3. You've put in Khan 1, 2, and 3. You've had almost a day of the SRA making submissions criticising the honesty and accuracy and completeness of that evidence, making all sorts of criticisms of it. And then you choose not to go into the witness box. Then it is open to the court, not necessary, not compulsory, but open to the court, if satisfied that the SRA has demonstrated a compelling case that there are allegations that need to be answered, to draw adverse inferences from the decision not to give that answer.
Well, particularly in circumstances where, as you pointed out, Khan 4 is responding in terms to your skeleton argument.
Yes, although, as I say, I only then responded to Khan 4 after the election on whether to give evidence or not. So
is what the judge says about that wrong? Because he says Khan 1 to Khan 4.
The Khan 1 to 4 were relied on, but because the situation with Khan 4 is that on the first day of trial, shortly before I opened the contempt application, my learned friend indicated to me that Khan 4 was coming. Yeah. We hadn't got a copy of it when the judge came into court, and it was served shortly thereafter during the course of the hearing. So effectively the learned judge had two options on this, either to give us some time to take instructions and consider it, and so on, or simply to say, let's keep going for now. And I asked the judge, and he accepted, and my learned friend agreed. The sensible course, given that I didn't know how long I'd need to take instructions on Khan 4, or that I could take half an hour to read it and then come back in and open, was to open on Khan 1 to 3 and take Khan 4 and deal with Khan 4 in closings.
Well, to be sure, but I don't think that detracts from the point as I was raising, which is you hadn't made opening submissions orally on Khan 4, but Khan 4 was a responsive document to your earlier written submissions.
Yes, my lord. And also not only to my submissions, but to the evidence.
And in those circumstances, it supports the proposition that insofar as Khan 4 doesn't explain something which might have been explained, then the judge is fully entitled to draw an inference.
Yes. Khan 4 is the totality of the answer to our criticisms, and all she asked to rely on. Yep. And when my learned friend came back into court after taking instructions and said, no, she's not going to go into the box and give oral evidence, but she does rely on Khan 4.
Yep. Now,
whether that was an error of the judge to allow that or not, I can't really assist the the court on that. I can see the force of my Lord Justice Arnold's reasoning, but we don't have
an error
authority.
in her favour. That's the only point that matters.
My Lord, having established then the principle that the learned judge accepted he could draw the inference, he then said at 123, which is page 94 of the bundle. Yes, it is page 94. Top of page 94, just at the end of the liability judgment. In making the findings in this section 3 of my judgment, I have not found it necessary to rely on any inference drawn from the fact that Miss Khan elected not to give evidence. And then he goes on to say that, however, I could have done, because almost all of them call for explanation. And he gave 2 examples. But it's the first sentence, I have not found it necessarily to rely on any inference. And in my submission, that is the end of ground 4. Because it means that there is, even if it is right, that the learned judge should have given a warning and failed to do so, Ms. Khan was deprived of her warning as to an inference. There is no serious procedural irregularity, which means that the order made below is unjust. And that is the test under CPR 52 that this court has to apply when dealing with an adverse inference. When dealing with a procedural irregularity argument. And in my submission, that is a complete answer to the suggestion. I'd be interested to see, as the court is, or what authority my learned friend has been able to find on this, if any, that in a criminal trial you would have to set aside the decision even if no inference was in fact drawn. Even if that's right, it doesn't bite in the civil appeal context, because CPR 52 requires the court to be satisfied that the outcome below is unjust.
I'm finding it quite difficult to envisage circumstances in which you would have a fully reasoned judgment in a criminal case in which the decision maker said, although the accused chose to exercise their right to silence, and I could draw inferences, I haven't done so.
I agree with it. It seems unlikely. I suppose, and this is just going from general legal knowledge, there are rare occasions, the old diplock courts and the new
Diplock courts in Northern Ireland.
gang-related provisions for sitting without a jury in relation to witness interference or jury tampering. It's possible one might find a case where something like that has been done. I assume that if a judge were to give a verdict in those circumstances, then in the ordinary way the judge's reasons would have to be set out. I don't know that's the case, but
I think in the diplock courts the judges did give reasons.
That seems constitutionally appropriate, because the jury doesn't have to, because of its nature, that a judge to be accountable must. And so I suppose if this point has ever come up in one of those rare occurrences, you might find it. That's the best I could think of for where to look, but I couldn't. I didn't really have time to deep dive on that.
In any event, as you say, the test in a criminal appeal is different from a test in a civil appeal.
And on a civil appeal, the question is the result below unjust as a result of a serious procedural irregularity? So even if there was a serious procedural irregularity as a result of the failure to give an adverse inference warning, the fact that the judge said he didn't draw any adverse inferences is, in my submission, the end of the point. And the suggestion in the company's skeleton argument that actually he must have done is, in my submission, unsustainable for 2 reasons. Firstly, he said that he didn't. There is no reason in the judgment to think that an experienced High Court judge was getting this wrong and did something he said he wasn't doing. And secondly, as I've shown you on the quest when we've gone through some examples of the evidence, I won't go through it again, there was more than sufficient evidence on the direct evidence and the evidence that had been given in Khan's 1 through to 4 to make the findings that the judge made. This is not a case where the judgment is thin on analysis of the evidence. And so there's every reason to believe the judge was completely accurate where he said, I didn't rely on any inference drawn. And the second point, we make as an alternative point, I do want to take you to this passage of the transcript, is that I made it completely clear in the openings that this was the point we would be making. And that is also in the core bundle. And the relevant passage is page 47C of the transcript of that day of the hearing, so it's page 218 of the bundle.
Oh, sorry, the core bundle.
Of the core bundle. Because I think it was appended to our skeleton documents at one point. But if you have it in hard copy tabs, it's probably behind tab 13, which contains the main appeal skeleton.
This is day one.
Day one, page 47 of the transcript. And we start, I said 47C, it's probably helpful to start just under A. Where we had been talking about Khan Ors. And I said that there was one other point that I wanted to make in my openings. And I said, in fairness to Ms. Khan, just under A, on page 47, picks up on a comment which came from your lordship this morning, and that is on the question of whether an inference could be drawn from Ms. Khan's failure to give oral evidence. Now, 47C, I make the point, it will be my submission, if we are in that situation, that you can draw an inference. But if I've opened the case on the basis that there are extensive inconsistencies in the written evidence which I will need to put to Ms. Khan, and she chooses then not to put herself in the position where she needs to answer that, then it is legitimate. I will not say it is necessary or it necessarily follows, but it is open to the court to draw the conclusion that the reason for that is she does not feel she has an answer to the questions I have foreshadowed, which would assist her case. And the authority I will take you for that, although it is to a certain extent by way of analogy, is again the Hussein case. And so then the submissions followed on Hussein, which we needn't go through because, my lord, you've seen the judgment and read the judgment in Hussein. Our debates about what Lord Justice Nugee said are probably not that helpful to Lord Justice Nugee or anyone else on the court. But I would note on page 48, you see that my learned friend Mr Bogle is also participating in those submissions. It's very much a three-way discussion. And so then the final point is at 49. I'd made the point at 49A that you can't, in a civil context, you'd see the decision in Preston Petrodel cited, and the point being that you can't draw an inference from nothing. You can't say there is no document here or no answer to this if there isn't something which establishes a case to be answered. And so I said at B, there must be something on which you then draw the inference from the failure to produce a document or the failure to give evidence on a point. And Mr Justice Leech goes through it, and ultimately we conclude that we're probably expressing the same point in a different way. And one sees how that then comes out in the judgment, paragraph 30. But it's F on page 49 that I just need to draw specifically.
48E.
48E.
Yeah. I was just going to say, my lord, quite, but that is, and then he says, but it is a distinction which is a fine line in practice, because, and then I say, well, it is clear in this sense, is it not, my lord, if she chooses not to give evidence, you cannot draw inferences from that.
Grateful to my friend. As I say, it was a three-way discussion in which various points were being put on both sides. And you can see from this that, as I said to my Lord Justice Arnold, we didn't take the point about oral evidence not being given when she was relying on the affidavits. But the point I need to make is, having shown how that was debated, and as you can see, it's several pages in the transcript, detailed discussion. Page 49, line F. I say the process of inference is ultimately the same. One is saying there is a question which has been put and there is a prima facie case on the documents and it has not been answered. And this is the crucial wording. This is the point I wanted to make so that it is clear now what I am going to say before Ms. Khan has the chance to make her election. If it is the case that we say there are inconsistencies and elements of that evidence which are implausible and contradicted by the documents and have not been explained or explained adequately, and Ms Khan chooses not to take the opportunity to answer those criticisms that I make, then based on the criticisms that I have made and the documents I have taken you to, you may draw the inference that there is no further answer to give. Now, at one point, if one looks at the grounds of appeal, one might think that there was a challenge to whether it is actually permissible to draw those inferences at all in the failure to give evidence. In fact, as the case has been opened, it's much more in my learned friend's submissions about the question of whether a warning was given. And you see that in the company skeleton where they distinguish as saying it's fact sensitive, the point doesn't deal with the question of a warning. My submission from this point of the transcript is that I gave a warning that we would be making that submission. And so if there was an irregularity, because the judge should have given it himself, then it's not something that's capable of causing injustice. Whereas in my submission, this operates at two distinct stages of the analysis. Firstly, we say our primary position. It doesn't matter who gives the warning. What matters is that the respondent who is making the election knows the position. And if it is made clear to her and to her representatives what is going to be said or what might be said or what inferences might be drawn, then the warning has been given. And it doesn't matter that Mr Justice Leech didn't say, now Mr Bogle, you've heard what Mr Alquist has said, and I formally warned Ms Khan that I may consider drawing such an inference. There was no ambiguity in it. And so in my submission, that is not a procedural irregularity. But if I'm wrong on that, and if there is an absolute rule that the judge must give that warning, then it's not a serious procedural irregularity capable of causing injustice, because there was in fact no ambiguity. And when, as the judge then records in his judgment, shortly after that, there was a 20-minute adjournment for Ms Khan to take advice and make her election, it's not really credible to think that it was done in ignorance of the clear warning that I had just given. And the case of Montreuil, which my learned friend took you to yesterday, is, we say, a fundamentally different case. That's a case where the trial judge had invited a litigant in person to give evidence without giving a warning. Andreevich, yes. Andreevich. That's the case where the trial judge had invited the litigant to give evidence without giving the warning about the right to silence. And in that case, it was said it is not enough that there had been an oblique reference in counsel's skeleton about the right to silence. Because even if that had been enough to register as some sort of warning or notification, it was completely undone by what the judge said. That's what the court decided in that case. And we say there's just no parallel here with the very clear warning that's given. So, my lords, there's no inference, and there's no injustice even if there was. Unless I can assist you further, or unless it would assist the court for me to deal with the supplemental skeleton now, those are my submissions. Unless, might I just check there's nothing else about me? No.
In which case, thank you very much, and we'll rise for 5 minutes.
All right. Oh, that's Nugee.
All right. Ah.
So we have Lord Justice Newey and Lord Justice Nugee, both sitting. Lord Justice Newey in the centre. Lord Justice Newey as we're sitting on the right.
Sorry, Newey in the centre.
Newey in the centre.
Yeah.
Nugee,
Yeah.
who you have there.
So he's the
on the
chap
right.
on the right.
Yes.
Still didn't recognise it.
The wigs make it very different, don't they? His Wikipedia page has a more
Gotcha.
notable.
And tell me to mind my own business, if you will. But in terms of procedure, let's work on the basis that you succeed in knocking back her appeal today. Is the result that she is going to go away for a year?
Unless anything else happens. Yes.
Nice.
There needs to be another order of the High Court, so I don't think it'll be at this hearing.
Right.
But
Yeah. I may have given my feelings away there. Cheers.
I was going to ask. I could do that, please. Sorry, the point. Sorry, it's late on a Wednesday afternoon. The point that there has to be an order lifting the stay.
no, staying in the dismissal, that's the other dismissal of the appeal. But no, there has to be a warrant issued. So Mr Justice Leech's expectation on the 10th of March was that there would have to be a short hearing for them to issue the warrant. He has ordered that the warrant should be issued. He has then stayed that, and so no warrant has been issued.
Right.
And
I follow.
must be issued before the
If they wish to do so, that they can make the order for the issue of the warrant. I mean, otherwise we're into Dickensian logic about the common pleas not being able to do things which are reserved. You know.
The Court of Appeal is very wide
Yeah.
jurisdiction to do anything necessary for the High Court.
Yes.
Let's cross that bridge when we come to it, but I think there might be something to be said for not having a hearing, but the only purpose is the issue of the warrant and the surrender into custody.
Because actually, not being public on passport or on the passport at the moment, she does that. They do that to get jurisdiction.
Let's not get ahead of ourselves.
No, I agree. I'm grateful to you for raising that point because we are going to be very, very keen to make sure that
This is effective.
this is effective and effectively promptly. I mean, if you were able to have a think about steps that we could. This is very far from my area, Philip. If you could have a think about steps which could be taken overnight, in particular whether they do have jurisdiction, and if not, whether they could, for example, Yes.
And so,
All right.
Sorry, my lord. I beg your pardon, my lord.
No problem. So, Mr. Alquist, you've completed your submissions at this stage.
Yes, my lord. But I'm just going to mention one more thing as I'm on my feet.
Yep.
In the slightly strange world of live streaming, a colleague of mine has been watching apparently with interest and has sent me an email telling me that there is an authority that you can. I'll bring this with me tomorrow once I've read it, but just to say that I've been told it exists, that you can rely on an affidavit even if you don't submit to cross-examination. And the name of that decision is the Discovery Land Company, LLC.
And Jai has.
Exactly, my lord. And my colleague said Lord Justice Nugee will remember it well. Yes, I understand my lord made the injunctions, which were then, it was said, breached.
Were breached.
Well, I was going to say it was said because I haven't read the judgment. But I've been told it's there. My lord, might I read it overnight? And since my lord has raised the point, if there's a relevant authority, I'd like to put it before you. But that's not really a point on the appeal, it's just for completeness.
Yes.
Thank you, my lord.
Mr. Bogle.
Oh, yes. Just one moment, my lord. I shall deal with my learned friend's points, if I may, my lord, in the sequence in which he made them. In his one of his initial points was in relation to CPR 81 and contempt proceedings. Civil procedures rules are law; they're mandatory. It follows that the court was bound to apply them, apply CPR 21. No option to do otherwise, and to ignore it would be wrong, and by inference, to borrow parts from the criminal procedure would be wrong. But of course he could do both. There's nothing to prevent him drawing important parts from the criminal procedure in quasi-criminal proceedings without in any way impugning or departing from CPR 21. Indeed, in my submission, the two go together hand in glove in some respects. And the only place that the right, for example, the right to silence is set out in the CPR is to say that it must be included in an application notice. There isn't anything else about, for example, the right to silence. So clearly it derives from some other jurisdiction. And the answer to that is obviously from criminal proceedings. That is where it derives. And in my submission, the court can quite satisfactorily decide that other appropriate parts of the criminal procedure can be, and indeed should be, transferred across in the case of quasi-criminal proceedings. Malone and Friends says that we're unable to say precisely where the criminal procedure begins and ends when it comes to quasi-criminal proceedings, such as committal proceedings. But that's not surprising. It's a matter for judicial interpretation by case law, and we've seen that there is case law dealing with it. There's nothing untoward about that. The fact that I can't give a complete code to set out how those criminal proceedings ought to be transposed across is not in any way untoward. We've seen from Deripaska what Lady Justice Khan says, and the 4 examples she gave, and this is how that particular part of the law would develop. As I say, there's nothing unusual about that. He suggests that the question is, what is the supposed deficiency in the Mental Capacity Act 2005 that needs to be augmented? And indeed, if I understood him right, he was saying that, well, if there is, then perhaps that doesn't make any difference to his submissions. What we are saying is that if the Mental Capacity Act is the only correct test, and we say that it isn't, but if it were, then the Pritchard test and the other criteria from the criminal jurisdiction, or something like it, very similar to it, ought to be part of the analysis. The analysis under both Section 2 of the 2005 Act and CPR 21(1) subsection 2. And in those, in carrying out that analysis, Pritchard and other criminal cases can be taken into account under the MCA test itself, and indeed, in my submission, should be. He then goes on to ask the question, well, what decisions need to be made? What are they? And he took your lordship to the White Book page 607 in relation to scope and definition. And contempt proceedings are not excluded. Well, we agree. It doesn't undermine the point that I was trying to make to your lordship. But the perhaps important point is that if a party lacks capacity to give evidence, then, as my lord said, Lord Justice Arnold, they can't decide whether or not to give evidence. If they lack capacity, it vitiates at a much more radical level. And that we respectfully agree with and adopt. You were then taken to the confidential schedule, particularly page 124, paragraph 14, where Mr Justice Leech said that one may consider what is said in Pritchard in asking the question about capacity, and by inference therefore agrees with the submission I've just made, and that there was a commonality between them, and I made this point in my opening submissions. At a high level of generality, it was a powerful factor. You recall the words, and a strong reason for refusal to allow the matter to proceed. Well, if you fail the Pritchard test, it may mean you fail the MCA test. That was my learned friend's submission as I understood it. But that's our point. Gupta thought she did fail. So, on that basis, in my submission, the judge needed further evidence to determine the point. He's not a doctor. He must have that evidence to be able to determine the point fully. Now, my own friend went on to say, well, in criminal proceedings, if you fail the test, then the 1964 Act applies, and in civil proceedings, CPR 21 applies, and the default position is to halt proceedings in order to get a litigation friend. That's correct. He then goes on to say what Mr Justice Leech was aiming at was appointing a litigation friend and then sending someone to prison may in itself produce an unfair outcome. But what we say about that is, in these circumstances, if she's a protected party, then it may not be wise to proceed. But that is why further and better medical evidence was required. And my learned friend went on to say that it sounded like he was making my submission for me. Well, in a sense, he is. What we're saying is apply Pritchard by analogy, precisely. It should be read into, or included in, perhaps is a better way of describing it, the Mental Capacity Act analysis. My learned friend then goes on to say, yes, but what it's really about, and what needs concern, your lordship, is findings, the judge's findings of fact, and that's not really about Pritchard or ground one. It's about findings of fact. Yes, but our point in my submission is that the judge's findings were necessarily flawed because he didn't have the full picture, and moreover declined to make a full and proper inquiry. He adverted to deficiencies in Gupta 2 and considered that he had not answered the points that needed to be answered. But the deficiencies, therefore, called out for further inquiry. The deficiencies in Gupta 2 needed answering and further inquiry. His conclusions were too serious for the court simply to dismiss them and to do so without further inquiry. I'll develop that point a little further in a moment. He went on to say that this was about that the case of Toohey and Griffiths, Supreme Court case, was about trials, not adjournment. And he said that Hyatt is to be preferred and that rarely would the issue of expert evidence require an adjournment. But with all due respect to my learned friend, our case is about a trial and not just an ordinary adjournment. The adjournment was what was required in order to facilitate what the Supreme Court has determined ought to be done and in order to achieve a fair trial. That's a very different situation from an ordinary application for an adjournment. He went on to say that he thought the judge had made no error and had concluded that there was no real prospect of persuading him and that ought not to be lightly impugned. Well, of course, we're not suggesting it should be lightly impugned. It's much more serious than that. We, in relation to the issue of whether a may should become a must in civil contempt proceedings, by dint of parallel with criminal proceedings, although there is no clear authority that can be presented by either side to your lordship, we say he is simply wrong. Perhaps the word ought would be better than must, but nonetheless, alleged contemners have a different status from other defendants. So in that context, may ought to become ought. And that, in my submission, is the correct approach for the court to take. The dicta of Lord Dyson in Mohun, when he was Master of the Rolls, that there ought to be a rigorous approach, is agreed and averred by our side. But all the more so, we say, because this is an issue of fairness of trial, and that rigorous approach in relation to the issue of fairness of trial and whether further evidence was required was lacking. my learned friend says that his suggestion would be that the assessment of the evidence is solely a question for the trial judge. The legal question as to whether the judge corrected himself as to whether what was fair is a question of law, but he also conceded, and rightly, where there's a breach of natural justice, there's a degree of tension there. There certainly is. If he thought the evidence was strong, he would have adjourned, says my learned friend, and he didn't think so. But in my submission, that's precisely where the error is, because he relied on evidence that was, in effect, partial in and of itself and in the context of the case overall. So turning then to Toohey and Griffiths, suggestion is that this is that we're submitting that this is a mandatory scheme or code rather than something that's very rare. We're not suggesting it at all. This is a new mandatory code. But we are suggesting that this is not a simple, straightforward ordinary Part 23 application for an adjournment. Far from it. And as I said already, it goes to the heart of the fairness of the trial. My learned friend says that an application for relief from sanction or to set aside a default on the basis of medical evidence, you would expect only there to be written evidence, but clearly this is not that scenario. We're not talking about a simple, straightforward application, Part 23 application for a sanction, relief from a sanction or to set aside a default judgment. We are looking at something that goes to the very issue of fairness of trial. Very different situation. And in any case, it's a different situation where there are committal proceedings, but particularly, as I say, where the issue is one of fairness of a trial. And the suggestion, therefore, that one can't simply read in a new code into Part 23 applications is entirely beside the point. It's not what we're suggesting. And we reject the premise that this evidence only goes to support a Part 23 application. It went to the whole proceedings. It's not just, as I say, any ordinary Part 23 application. The application was an application that was required for fairness, for the fairness of the trial. And the judge himself admitted, in effect, that principle by saying that if there had been, as he saw it, cogent evidence of unfitness or incapacity, that would have necessitated a very different result, precisely. Therefore, the parties should have been given an opportunity to obtain further and better evidence, or at least inquiry. The learned friend drew your Lordship's attention to paragraph 63 to 4 of Toohey and Griffiths. But none of these apply, in my submission, to Gupta 2, and indeed Mr Justice Leech doesn't suggest it. Well, of course he wouldn't, because Toohey and Griffiths came later. But the exceptions are not novel. But they're not even hinted at by Mr Justice Leech. None of the 8 exceptions in my submission apply. They're aimed, in effect, as is clear on the face of the case, where the evidence is so untenable and unsustainable that cross-examination simply wouldn't assist. That's very far from the case here. And this court can, in my respectful submission, take judicial notice of the background to the matter in looking at Gupta 2. Moreover, Gupta 2 is, in my submission, very far from implausible on its face. So, to that extent, even if the rule in Brown and Dunn is not of universal application, it or something like it certainly seems to apply here. My Lord Justice Arnold made the point or question that there can be no fair trial if an adjournment is not granted on medical grounds, where they are justified, of course, because a fair trial matters more than the simple issue of an adjournment. And we respectfully adopt that proposition, which must be right. An learned friend seeks to take reference in the overriding objective. But the overriding objective also requires justice, and that in turn requires a fair trial. So obviously that won't be obtained if there is any clear situation where of the possibility of the trial being unfair. We say there is. My learned friend then took my lord to the confidential schedule, and he went also to the judgment of Mr Justice Leech on liability as well as sanction. But at page 125 of the core bundle, paragraph 16, he made reference to Mr Justice Leech's comments on Dr Gupta's evidence. Now, we don't deny that his evidence is deficient or even seems to contradict Gupta 1 or other evidence. That is precisely our point as to why full and proper evidence is needed. But the conclusion, as I say, on its face, Gupta 2 is plausible. Gupta 2 is not, doesn't fit into those 8 categories where it's so far removed from reality that further inquiry or cross-examination isn't called for. The conclusion, moreover, was serious enough to call for further inquiry, particularly given that the consequences of both his conclusions and Mr Justice Leech's decision in these proceedings were and are serious. Dr Gupta at one point refers to the position of my client on one of her positions as delusive. My learned friend drew the court's attention to that, but sought to skirt around the main principle and main point here by saying that an unwise decision doesn't mean that there's an inability to decide and therefore a lack of capacity. It may simply be vexatious. Well, it may be, but in my submission, it's quite clear that more than sufficient is raised by Gupta 2 to put the court on inquiry so that further evidence is needed. I may add, in passing, that my client, despite being a defendant in the case concerned, has now the crowning glory of a civil restraint order against her. That ordinarily points to vexatiousness, but in the context of this case, in my submission, simply lends further support to at least a certain extent to Dr. Gupta's conclusions, and in particular perhaps his conclusion as to a position being delusive. And as my learned friend and Mr Justice Leech seem to say, the Pritchard criteria may inform an MCA, a 2005 Act analysis. And therefore, if this is part of the Pritchard test, then it too is relevant to an MCA analysis. If you're delusive...
If what is part of the Pritchard test?
If his description of her position being delusive, if whether or not that is further underscored, if I can put it that way, by the fact that despite being a defendant, my client now has a CRO against her, would seem to go to the Pritchard test. And in that respect, and this is really a repeat of the submission I made before, ought to be part of an MCA analysis. I'm simply giving that by way of an example. My learned friend then took the court to the further series of criticisms by the judge of Gupta 1 and 2, and obviously in relation to that I make the same submission I just have, and their inconsistencies with other evidence, paragraphs 21 to 23. But again, those inconsistencies only re-emphasise the need for full and proper medical evidence, and not medical evidence obtained at very short notice, 10 days, which is necessarily terse and brief. for example, they could have been provided not necessarily any expensive or lengthy delay, but something much more straightforward. For example, a single joint expert report, or questions put to Dr. Gupta. Various options were open in my submission to the judge, other than merely dismissing Dr. Gupta's very serious conclusions. And it, as I say, wouldn't require any great expense or delay, particularly, as I say, in the light of Dr. Gupta's explanations being on their face not implausible. And this is in addition to the reservations that were expressed by her legal team, not only in these contempt proceedings, but also, of course, in the earlier contempt proceedings, where the judge was again Mr. Justice Leech. You were then taken to paragraph 14 and 15 of the confidentiality schedule. Well, once again, we accept and aver what is said there by the judge. The question isn't whether Mr. Justice Leech applied the wrong test. It's the way he exercised his discretion. That created the possibility, indeed, the grounds and position of an unfair trial. And so, for that reason, he ought not to have dismissed Gupta's conclusions without further inquiry. He said, as I've noted, that he would have reopened liability if he was convinced that my client was a protected party. But you have my submission that he shouldn't have made that determination until he had embarked upon further inquiry. We're not suggesting that by any means that this court or any court should be requiring that every piece of medical evidence necessitates cross-examination. But evidence that is adduced that might undermine the fairness of the trial may and arguably should be subject, at the very least, to further inquiry, if not cross-examination. My learned friend said that this court should be loath to interfere in the exercise of discretion, but certainly this court should do so if it led to an unfair trial. If she wasn't fit to stand trial, then the trial was not fair, no matter what Mr. Justice Leech might or might not have done. Without further medical evidence, he ought not to have reached the conclusion he did. Indeed, he made assumptions, and as I said in my opening submissions, effectively begged the question at issue, and didn't need to do so, when he could and should have answered it by further inquiry. My learned friend then took your lordship through the evidence that had occurred after the trial and also in the skeleton arguments, sorry, not the skeleton arguments, the affidavits of the appellant. To the extent that that was relevant, what we say about that is that the inconsistencies that have been a feature of the appellant's case are what would normally be something that would impugn her position. In this particular case, simply add fuel to the argument that, and indeed the fact that she has clear medical problems, mental health problems, and underscore the difficulties that I've already drawn your lordship's attention to, namely that her legal advisors and representatives were under a dilemma. The best that they could do was to try and make sense of the instructions that they were given, and in the context of the case and of what the court was seeking to have explained, produce affidavits which would attempt to reflect the instructions insofar as they cohered as best they could in the client's interest, but also to assist the court. There, inevitably, if a litigant is suffering from mental condition, there are going to be problems and inconsistencies, as night follows day. If anything, that simply underscores the point that I'm making.
Can you just help me to understand this? I understand your submission that a person who has mental health difficulties may be confused and may be inconsistent. But why does the telling of a lie show that a person has mental health difficulties?
Well, for a number of reasons. Firstly, they may not appreciate that it is a lie. They may simply not understand, having made statement A, which is inconsistent with statement B, that they have in effect.
How about I use this email address purely for personal purposes and not for work purposes, when the evidence demonstrates the contrary? It's a lie. Why is that?
Or it may be
a mental health difficulty.
It may be a lapse of memory. And if you have mental health issues, there are going to be lapses of memory. There are going to be cognitive dissonances that can't be explained in the ordinary way, that cry out for further medical evidence so as to make it clear to the court, so that the court can arrive at a judgment as to whether this is, as your lordship puts it, a simple, straightforward lie, and therefore impugns the integrity of the witness, or whether it is the product of some cognitive dissonance caused by the mental defect. A person may be a schizophrenic, for example, or may be suffering
But
from...
that's not the diagnosis here.
No, of course it's not, but I'm just giving an example. Or may suffer from, say, bipolar condition or some other serious mental illness. And they may be sitting in a room, or for that matter, a courtroom. They may appear to be lucid, to be giving coherent communications, but the truth of the matter may be very far removed from that. And until such time as there is an obvious and open manifestation of that mental condition, an observer isn't going to know one way or the other. The only way they're going to know, that includes any observer, including, of course, a judge, is to have the medical evidence that will be able to make that clear. And it may, of course, be that the medical evidence says, sorry, no problem here, nothing to see, let's move on, in which case, as your lordship rightly puts it, it would just be, on the face of it, a terminological inexactitude, if not an outright lie. So that's why, in effect, these inconsistencies simply underscore the need to have that additional evidence. My own friend then touched on the issue of, well, I think my lord said, well, that's the issue of whether the affidavit should or should not have been put forward as evidence. I'll come back to that. That's the. I have in fact got some copies of the case of Deutsche Bank, which I hope may be of assistance to the court. In addition, my Lord Justice Nugee asked if we might find some references. My own friend now says he's found one, and I haven't seen it yet, so I don't know what it says. But certainly, this side of the fence scoured for any references in Archbold, and I'm sorry to say none were found, and colleagues were consulted. The best that they could say is that the issue of inferences from silence was regarded as so straightforward as almost to be trite. But I'm afraid that's not very helpful to this court. So I can't take at this stage that any further, but we will continue our investigations to see if we can find anything useful to assist the court. It's also been said, and indeed the judge himself said on page 94, paragraph 123, your lordship has taken to that he didn't draw any inferences from silence. But that, I must honestly say, is open to question. If one reads the judgment, it's clear. It's not entirely clear that some inferences weren't drawn from the silence of my client, and indeed informed the judgment that the court made. It's very easy to say, I draw no inferences from silence, and then to go on to condemn the person who has been so silent in the face of evidence or not. But in my submission, certain inferences were drawn. And whether that was right or wrong, it does tend to impugn, or would, if I'm right, what the judge says at paragraph 123, but I can't take it any further than that at this stage.
I'm a bit puzzled by this. The reason, as will be apparent from questions I've been asking earlier, but in what way was your client silent when she was permitted to rely upon not one, not two, not three, but 4 affidavits,
Yes.
the last of which ran to 112 paragraphs?
Yes.
In what sense is that silent?
Well, that's a very good question. The position is simply to take it chronologically. In the first contempt proceedings, her legal advisors already being concerned about her mental state, I can't take it any higher than that without getting into privilege issues, had to advise as best they could, and if they were dealing with somebody who had serious mental issues that we now know as a result of Gupta 2, or at least we now are on notice of as a result of Gupta 2, may or may not have been sensible instructions, and advice may have fallen on deaf ears. But the position at that stage was that she decided not to give any evidence. Well, whether on advice or not, she gave no evidence. But she was represented at that time. Having given no evidence, she was then found to be in contempt. Now, admittedly, there was an admission, at least in respect of one of the contempts. But on the other, all of the contempts, she was found to be in contempt. All of the allegations, all of the were said to be proven. Now,
I'm sorry. What you just said is factually inaccurate. The position taken on the first contempt application was that there was no contest on liability. No, I'm sorry. I'm misspeaking. I apologise. I withdraw what I've just said. I've just realised I'm making a mistake. So please carry on.
Yeah, I'm sorry, my lord. So what the position at, I have to be cautious here, there are privilege issues, on the second committal was that for whatever reason she was represented, and for whatever reason she decided that she would put evidence before the court to attempt to explain why it was she was not able to comply with the orders that were made and the requests by the SRA for the documents that were set out. I may add, her position, albeit I accept, with inconsistencies, some of which have been pointed out to the court by my learned friend, and which we say, as you've heard me say, go to the issue of her mental state, was that she had no documents to hand over. Now, I'll come on to this later, but there is an authority which I will, with your lordship's permission, provide to the court to assist the court, that reminds us that whilst a contempt in actus reus terms has taken place, it can't take place if it's an impossibility. And whilst I'm not arguing, because this is a matter to be argued before the first instance judge, that what was being asked was impossible, but in fact, in terms of actus reus, but in terms of her mental state, which is important for this court, it might have been, and in my submission was, arguably an impossibility, because she didn't have the mental wherewithal to be able to fulfil the order of Mr Justice Miles and the request of the SRA. Not only did she argue, I haven't got the documents, and we saw how Mr Justice Leech responded to that.
I'm sorry, we seem to be at cross purposes, because you were making a submission about drawing inferences from silence, and my question was, how could your client be regarded as having been silent when she'd made 4
Yes, I
affidavits
do
and
beg your
chosen
pardon,
to
my lord.
rely upon them? You're now arguing a completely different point.
I moved on to another point. I should have answered your lordship's point first. So she filed the evidence in order to be able to explain, I don't have the documents, and to counter the assertions that were made to her. Now, that ordinarily would be evidence that she had taken on board what was said in the orders by the SRA, by the court, and was responding to it. But in the circumstances of her mental state, given the decision to decide to file whatever evidence was available to her to file, all that could happen was she gave it instructions such as were possible in her then mental state. And we don't know what that mental state is for all reasons.
You've been over that ground, and I
have,
understand
many
your
times.
submission. So can I rephrase my question in this way? This is not a question of silence or of adverse inferences from silence. The correct analysis, I would suggest, is that this is a scenario where a litigant gave a full account of herself in 4 affidavits, but chose not to give oral evidence and be cross-examined in the face of a warning that if she chose to take that course, the court would be invited to draw an adverse inference, not from the silence, but from the failure to submit to cross-examination. If indeed that was what the judge did, contrary to what he said in 123, what's wrong with that?
Well, your lordship made the point yourself. This is an extraordinary situation where affidavits are produced and relied upon without cross-examination. There's no way that that evidence can be tested without cross-examination. I respectfully adopt your lordship's point, number one. But in answer to the question, what about the fact of production of those affidavits? Well, they are, as in the usual way, mediated by her solicitors, her legal advisors.
Yeah, well, that point I understand.
And, they are doing the best they can with perhaps instructions that perhaps do not cohere well in order to try and put what they understand to be the case from those instructions that do not cohere well, so as to put the client's case as best they can, obviously without misleading the court, and that is what they did. Now, that was preferable, it was thought, by somebody, to complete silence, as what happened in the first contempt proceedings. The result was, not only did it make no difference, but it also created the issues that we're now canvassing before this court. And so it's not, in my submission, the proper approach to adopt to say that is evidence of coherent thinking, of being able to respond, to understand, to stand trial, to be fit to plead, to give instructions. In fact, in my submission, it tends to support the opposite view, precisely because of those inconsistencies. But the fact that those 4 affidavits are there do not in and of themselves undermine that submission. But as your lordship rightly says, it is rather extraordinary that they are indeed relied upon both by the court and indeed my client, where there is no cross-examination. On that, my lord, if I may. And
As I understand it, we're dealing with adverse inference at this stage.
My lord, yes.
Have you not covered that ground?
Yes, we have, Bargy. But just to make the point, those affidavits were taken into consideration, of course, by the court, but only negatively, in effect. They're not, it wasn't, as my lord said, it could have been, it could be said that this was a mistake
But are you not going on to something that has nothing to do with the grounds of appeal?
I thought that was partly what my lord was driving at, but if I got it wrong, I apologise.
I'm conscious that actually on your timetable we should have moved on to the next.
Yes, I do apologise.
And we've gone past 1:15 now.
Yes.
Anything else to say in reply on the main appeal?
My lord, yes. Well, the other point, if I may just very briefly say, is that in our case is that it does matter from whom the warning comes. It's insufficient that it comes from the, if you like, prosecution side of the case. The position, therefore, is that even to this day, my client can't compute, if that's the right word, what the SRA want from her. Every excuse that she provides does not address what they need. Why is there no compliance in that respect? In my submission, that's because of her mental state, and that the possible explanation and probable explanation is psychological impairment, and Gupta too suggests so. Mr Justice Leech's conclusion, which as I say was before the case of Toohey, when Toohey changed the game to some extent, where there is evidence that goes to the root of the issue, in my submission, it should not be dismissed without further inquiry. And if the judge did err in allowing, and I suppose this is the point I was just making to my lord, allow her to deploy her affidavits, that isn't necessarily an error in her favour, because, as I say, they were used against her. Had this not been an option, and she had not deployed them or made them, or alternatively, if she had allowed herself to be cross-examined on them, things might have been very different. So it's not, in my submission, necessarily an error in her favour. I just have one or two other submissions to make, my lord, before I conclude. Very briefly then, and as swiftly as I can, affidavits, I've made this point to some extent, and I'll develop it a little further, are settled by solicitors. They can't give evidence as to the process of how they came into being. One can only rely upon the knowledge, judicial knowledge, as to how that happens. It's possible that my client thought she knew what she needed to do to purge contempt. But the reality might be very different. By analogy, it's possible she thought she knew what she needed to do to comply with the order. But again, the reality might have been very different. The instructions she gave in relation to the affidavits, without saying what they were, may also have been, or appeared, lucid and or cogent. But given the conclusions of Gupta too, it is, in my respectful submission, entirely plausible that they may have been based upon entirely flawed understanding of the facts and or obligations caused by her neurodivergent condition, combined with other factors. Affidavits have to be gone through by solicitors, trying to make sense of them and turn them into an affidavit which they thought reflected her instructions best, and which she then, either with or without full mental capacity, approved. And any evidence filed in response to the skeleton of the SRA, for example, in particular, Khan Ors, could have been identified by solicitors as being something that required an answer. Doesn't mean that the appellant necessarily understood or could process the point, knowing that is what we now know from Gupta too. It's possible that things missing from her evidence might be because she couldn't process what was being alleged, hence the unanswered points. Her evidence and submissions show that her solicitors and counsel understood what was being asked of her and engaged in the criticisms of her in the skeleton and contempt application. Whilst any affidavit was produced in line with the rules and professional obligations, it isn't necessarily the case that the appellant herself did so.
Well,
Even if
you need to be a bit careful. The rules and professional obligations make it entirely clear, and we all know this, that solicitors and counsel can't make up facts.
Of course.
And so if there are factual statements in the affidavits, we can proceed, I assume, on the
Yes.
basis those facts come from her instructions.
Well, they may come from her instructions, so they may, of course, come from something more independent.
Well,
If they come from something more independent, then there's no problem for a solicitor or counsel. But
yes,
if
but
they,
when they're her affidavits, she says, this is my explanation of this point, and we were shown some examples. Can we not assume that that was coming from her?
but you can assume that it's coming from her.
Yes.
But the problem, my lord, at the risk of repeating myself, is that you can't be at all sure that it's coherent, or that it has any bearing on reality other than what is said at face value. And the only way we're going to know that is, as I've said many times, further medical evidence.
Thank you.
And,
On the face of it, one receives instructions, one assumes they're coherent, and one acts on them, but that doesn't necessarily mean they are. So just finishing briefly with this, my lord, I apprehend your lordship was about to say something.
no, keep going.
And as I say, Gupta 2 points puts a very different light on all of that. And moreover, well, I think I've answered that point. My lord, I have been asked to make some other submissions.
Well, they're not going to be made tonight. What
Maybe,
would they be on?
maybe not tonight.
What would they be on?
Well, they're a bit of a mixed bag, I'm afraid.
Relating to the main appeal.
Relating to... One moment, my lord.
I mean, they would have to
I think they would be best made tomorrow, my lord,
Well,
because
yes and no.
they're a bit of a mixed bag.
They would have to, for them to be proper at this stage, they would have to be in reply to
Of course.
things that Mr. Alquist said.
Of course. And I need to, they've come to me rather late, I need to sift them to ensure that they do comply precisely with what your lordship has said.
Now, in terms of tomorrow, we can't sit till 10:45.
Beg your pardon.
We're content to sit, if necessary, till 1:15 to ensure that we make up the time. But we do want the case finished by 1:15 tomorrow.
If it helps, my lord, my submissions on 829 will be brief, and my submissions on 237 really have already been made.
I mean, I have had the impression we've covered an enormous amount
Yeah.
of ground.
But there is one ground which, well, to be frank, I'm not sure it is a ground, and I may have to ask for an amendment to allow the ground in, which your lordship may decline. But it does deal with an issue with which my learned friend is very familiar, which was raised in the slip rule application. The slip rule wasn't appealed because it's almost impossible to appeal a slip rule application, but the underlying point is nonetheless one that should be made.
If
And that
there-
won't take me long.
If there is any additional ground of appeal that you wish to seek permission to pursue, I think it should be put into writing and supplied to Mr. Alquist, preferably tonight.
I have done that, and I will supply it to my
Okay.
learned friend. But again, even if your lordship allows that amendment, it will be necessarily brief. And as I say, the rest of 2637 has already been covered. So I'm hopeful.
That was what I'm hopeful of. I mean, we do seem to have covered an enormous amount of the ground, but I do think we ought to finish by 1:15 tomorrow.
Very good, my lord.
And I'd be grateful if the advocates could bear that in mind in framing their submissions.
Certainly will, my lord.
Well, before the court rises,
Yes.
just to put this point down, I, having taken instructions, do need to make a brief objection to some of the evidence, as we say it will be, as we say it was, that has been given in reply, as to the way in which the affidavits were prepared and some of the points about mental health. I'm happy to do that in the morning.
You say that, but we haven't received any evidence.
Well, I mean, that's precisely my point. My lord. There was various assertions about mental health and cognitive dissonance and the way it may have affected the evidence that Ms. Khan gave on, for example, the email address. And my point is, there is no evidence of that. And similarly, on the preparation of the affidavits, my point is, if my learned friend wants to make submissions suggesting that actually the affidavits may not reflect entirely what Ms. Khan wanted to say, and there are issues around how that was prepared,
I really think
then there must be a waiver.
We have the evidence. We've heard the submissions on each side. I can't see any basis for allowing further submissions from the SRA on this aspect.
Well, my lord, I think I've probably expressed the points anyway, and I wasn't intending to do any more than put the marker down that we didn't accept there was evidence on to support my learned friend's submissions.
10:45 in the morning.
Thank you.
Thank you, my lord.